Good morning. I'm delighted to introduce this morning our two panelists, our two speakers. The first to go is Professor Susan Tiefenbrun, who is a professor of law at the Thomas Jefferson School of Law. She's also the director of the Center for Global Legal Studies, and her area of expertise is semiotics. She's recently published a book on semiotics entitled Decoding International Law, Semiotics and the Humanities, which has been published by Oxford University. I'm also delighted to introduce the second speaker today, who is Professor Wouter Werner at the VU University in Amsterdam. His specialty is international legal theory, and he's on the board of the Association for Semiotics of Law. He's also the director of a research group called the Boundaries of Law, which involves the study of philosophy and law. Professor Werner is also with the European Network on Constitutionalism and the Fragmentation of International Law. So without further ado, Professor Tiefenbrun.
I'm going to stay up here because I need to get my slides up. So once you get it up, I can click. Good. Thank you, Michael Scharf, Force of Nature, who organized this and many other conferences. I'm honored and delighted to be here. Lawfare, what is it? It is a weapon designed to destroy the enemy by using, misusing, and abusing the legal system and the media in order to raise a public outcry against the enemy. It's a clever play on words, a pun, a neologism, a new coined word, that needs to be deconstructed in order to explain the linguistic and the political power of this term. Lawfare creates a very interesting and shocking equivalence between two words, law and war. And semiotic theory can help unpack this play on words. So in the 13 minutes allotted to me, I will apply semiotic theory to expose the meanings of the term lawfare and to try to interpret it. First, I will look at the definitions of the word law, as well as its text, context, pretext, subtext, denotations, and connotations. I'll do the same thing for the word war, in order to better understand the identity created between the law and the word in the term lawfare. The linkage of law and war is most clearly manifested in the expression of a just war, or in the elaboration of the laws of war. Both law and war enjoy power. And it is precisely this shared power that constitutes the basis of the use of lawfare as a weapon. I will look at the different techniques of lawfare and the serious impact of that usage on politics and on the whole integrity of our legal system. So next, what is law? And I can't do justice to that question, obviously. You have to look at legal theories, different jurisprudential theories of the law, such as natural law, legal positivism, legal realism, and sociological jurisprudence, each of which stresses different aspects of the overarching concept of law. Natural law is divine law, lex aeterna, eternal law, unchanging law, normative jurisprudence. Positive law is changing law. It is a word derived from the Latin positum, which means established, and thus Positive law is laws, codes, statutes, treaties that have been established by human beings. Legal realism is a theory that derives not from the idea of rules or principles of statutes being the nature of law, but rather on judicial decisions that derive from social interests and public policy. Sociological jurisprudence frames hypotheses on which to base general laws and the operation of law in society. In the early 20th century, following the work of John Austin, a guy named H.L.A. Hart pursued a modern positivist conception of the law and of the importance of rules, which he established in the very famous book that you all know, The Concept of Law. By adhering to the discipline and constraint of obedience, rules and the law paradoxically bring liberty to people, freedom, create liberalizing order, consistency, stability, and thus power in society. Oliver Wendell Holmes, who, by the way, was a great friend of a semiotician, no less than Charles Sanders Peirce, one of the fathers of semiotics. Holmes stressed also the power of the law when he referred back to the origin of legal procedure as vengeance. In order for you to understand the paradoxical, contradictory, and ambivalent nature of the term law, I'd like to just tell you what Holmes said about the law in a very poetic passage in which he referred to the law as his mistress, only to be wooed with sustained and lonely passion. He said, "When I think of the law," and it's right up there, "we know her in the courthouse and the market. She seems to me to be a woman sitting by the wayside, beneath whose overshadowing hood every man shall see the countenance of his deserts or needs. The timid and overborn gain heart from her protecting smile. Fair combatants, manfully standing to their rights, see her keeping the lists with the stern and discriminating eye of even justice. The wretch who has defied her most sacred commands and has thought to creep through ways where she was not, finds that this path ends with her and beholds beneath her hood the inexorable face of death." Oliver Wendell Holmes. He too saw that law has many qualities. Law can be conceived of as rules, as interpretation, as liberalizing rights, as imposing commandments, as constraining and providing duties and responsibilities. But there's no doubt, within all these different definitions that I've given you today, there's one thing in common. Law is power. So, what is war? We are told that war is hell, except when it is noble, thrilling, profitable, and convenient. The word war comes from the Middle English term were and the Old High German term ware, both of which mean strife and confusion, and both of which clearly have negative connotations. But in the Middle Ages, the concept of war was acquiring an ennobling, positive connotations. Warriors and knights were glamorized as heroes, despite the havoc and the destruction that war wreaked on civilians. The most, I think, interesting illustration of the duality of this term is from the Latin word war, which is bellum, and ironically, the declined form of bellum is bellus, which in Latin means beautiful, charming, handsome. War and law both have positive and negative connotations. In the Middle Ages, the positive connotation of war was so amazing that one writer said, war is a joy. It is a joyous thing, is war. You love your comrades so in war that when out of that there arises such a delectation that he who has not tasted it is not fit to say what a delight it is. Wars in the 17th century were very limited in objective and scope. War in the 18th century was a limited instrument of national policy. War in the 20th century, World War I in particular, was a total war. The entire population and the entire economy was mobilized for a prolonged period of time. Modern war is asymmetrical, in which the basic distinctions of battlefield and uniform are eroded. What is asymmetric warfare? It's an attempt by paramilitary organizations to erode the distinction between combatants and non-combatants, and between military and non-military targets. And because asymmetrical warfare is in direct conflict with the military terms of necessity, proportionality, distinction, and humanity, it is very difficult for us today to speak of asymmetrical warfare and just war. What are the laws of war that control and protect civilians, soldiers, and prisoners of war? I haven't got the time today to go into the history of the laws of war. Suffice it to say that there are many. There are codes. They go back to the 6th century BC when Sun Tzu wanted to regulate the way wars were conducted. It goes back to 200 BC in the Hindu Code of Manu, where they spoke of war crimes, the Geneva Conventions, and the basic principles of customary law that I spoke about a moment ago. So now let's get to the main point. We have unpacked law, unpacked war, talked about laws of war. What is lawfare? Well, sitting here today is Charles Dunlop, who was the first to coin the term, and he defined it as a process, a legal process, a weapon in modern warfare to achieve a military objective or to deny an objective to the enemy. Later, he expanded that definition, explaining that, and this is important, lawfare is the exploitation of real, perceived, or even orchestrated incidents of laws of war violations, being employed as an unconventional means of confronting a superior military power. And the definition has even further been expanded to the wrongful manipulation of the legal system to achieve strategic, political, or military power. Lawfare is effective because one lawsuit can silence thousands who have neither the time nor the money to challenge well-funded terror financiers or the vast machine of the judicial system. What are the techniques of war, of lawfare? There are three. The initiation of lawsuits before courts in the international system, the International Court of Justice, the International Criminal Court. Two, the misuse of legal terminology to manipulate international institutions and to create negative opinions about the enemy. And three, the prosecution of foreign nationals in domestic courts for military and civilian action. An example of each, very briefly, the filing of malicious libel suits, libel and hate speech lawsuits brought against writers, politicians, journalists. Today in the New York Times, an article about the journalist from Denmark who was sued because he put a cartoon in the paper about the Prophet Muhammad, and today the president of Germany said, you have the right to speak. But because these lawsuits, these harassment lawsuits, workplace harassment lawsuits, libel tourism, seeking good forum for suing in Britain, very easy to sue for libel in Britain, because there the plaintiff does not have to prove the guilt of the accused, but rather the accused must prove their own innocence. Completely opposite manner of procedure from the United States, where we have a presumption of innocence. So these lawsuits, these hate speech cases, many of which are in Europe, in the Middle East, they sway public opinion against the United States, against Israel. And the problem with these lawsuits is they chill free speech. I will be done in 2 minutes. The next type of lawfare is universal jurisdiction abuses. And many have denounced universal jurisdiction cases where Bush and Clinton and Tony Blair have been, there have been attempts in Belgium, for example, to prosecute Blair for war crimes, as well as Jordan's demand for the extradition of a controversial Dutch politician to stand trial for blasphemy of Islam and for bad feelings about the Muslim religion. Gaza report, UN investigative report, resulted in an international outcry against our friends, Richard Goldstone, Christine Chinkin, because the report accused Israel of war crimes. Some have even argued that the Nuremberg trials could be called a kind of universal jurisdiction abuse and lawfare. So to conclude, the abuse of the legal system, of human rights laws, and of humanitarian laws by lawfare undermines the overarching goal of world peace by eroding the integrity of the legal system, by weakening the global establishment and enforcement of the rule of law. The manipulation of the Western court systems, misuse and abuse of European and Canadian hate speech laws, and libel law procedures can destroy the very principles of free speech that democracies hold most precious. Lawfare is not a benign weapon of war. It bases its strategy on using the law to gain negative publicity for the enemy country. It is an assault on the people of free nations to exercise their constitutional rights of free speech under both international and domestic law. The lawfare users are fighting freedom and attacking those who have the right to speak and to act openly. The weapon they use is the rule of law, which was originally created not to quiet the speech of the innocent, but more to subdue dictators and tyrants. Ironically, it is this very same rule of law that's being misused now to empower these tyrants and to thwart free speech about national security and about public concerns. Lawfare is an attack on the sovereignty of democratic states. It's a pun, a not so funny play on words, based on the shared power of the law, which is strong as the power of military might, especially when it is misused and abused. The continued use of lawfare will erode the integrity of the national and international legal systems and will, I fear, result in the increased and unfortunate use of warfare to resolve disputes. Thank you. Trying to get rid of it? How do we get rid of it? Escape. Law and war. Escape is everything. Where do you have it? Escape. You can't escape. We need protection. These metaphors are terrific.
Thank you.
Thank you.
Okay, first of all, I'd like to thank the organizers, and in particular Michael Scharf, for inviting me here. It's wonderful to be back here. My very first conference in the States was also here. It was a roundtable for the semiotics of law, and I'm here in the session on the historical and semiotic origins of lawfare. When I was invited to this conference, I thought I had a, well, more or less clear idea what lawfare was all about. At the time, I thought lawfare stood for the way in which all participants in contemporary wars, governments, the military, NGOs, human rights groups, all used law to pursue their own strategic ends. That lawfare was, in David Kennedy's words, the art of managing law and war together. But then I was soon to find out that that's not how the term is used mostly nowadays. I was to find out that nowadays lawfare is mostly used as an instrument to denounce people who fight particular governments using legal means. And I found that intriguing. How is it possible that one and the same concept is used for such different agendas? How is it possible that such different and even opposing meanings are attached to one and the same concept? And it shows, I think, that lawfare is a very powerful concept, that it's worth struggling over the meaning of lawfare. So what I did in my paper is try to take a few steps back and look at the, well, genealogy is maybe too big a word, but something like a genealogy. How did it occur? What are the different contexts? What are the different social practices in which the term lawfare has been used? And as the title of my presentation shows, I found it quite curious to see how it evolved. And I found 4 different meanings, and unfortunately I only have 13 minutes, so I'll need to skip the first one, from yin and yang to unrestricted warfare, although that is the most curious one. And that's the how it started in the 1970s in a book a book chapter that pleaded for peace, harmony, and love, and a balance of yin and yang in society, and then advocated a turn to the East in order to remedy everything that was wrong with Western legal culture. And then an ironic move, because then lawfare appeared in the book of 2 Chinese officers, but there was not much harmony, peace, and love going around. It's one of the most grim pictures of war that you can imagine, where actually the whole Clausewitzian definition of war is turned around. War is not seen as the continuation of politics, but society and politics is seen as the continuation of war. But I can't go into that now, unfortunately, because of time reasons, and also because if I need to select, I think the other 2 are more interesting because they will most likely appear later on in the discussions that we'll have today. So, the second one, the legalized war, that is, I think, the very first context in which the term lawfare appeared. It's the realization at the end of the 20th century, early 21st century, that the relation between law and war has significantly changed, that nowadays law is omnipresent and lawyers are omnipresent in military affairs, and that new relationships have been built between humanitarians and the military. The classical example that's generally given is the Kosovo operation, where lawyers influenced military decision-making at all kinds of levels. And this is also where Major General Charles Dunlap came up with his definition of lawfare as the strategy of using or misusing law as a substitute for traditional military means to achieve an operational objective. Now, Major General Dunlap will be presenting in the next session, so I don't think it makes much sense for me to delve into his work here now. But I'd like to stress one thing here, that at least in the way I understood it, what the term lawfare does in this context is mainly try to capture this new relationship between law and war. It's not meant as an instrument to denounce activities of others per se. Whether lawfare is a good thing or a bad thing depends on the concrete circumstances in which law is used and for what reasons. Having said that, of course, the strategic use of law still raises fundamental questions, for example, regarding the integrity of law. What is left of the normative independence of law if people all use them strategically and know, reciprocally know, that they do so? Well, that is a question that figures prominently in the book that was my entrance to the concept of lawfare, David Kennedy's On Law and War. And David Kennedy, in this book, sketches how, in the past few decades, the international humanitarian law, or the laws of armed conflict, whatever you want to call them, have become kind of a common vernacular or common vocabulary for assessing, discussing elements of war. And that every participant in contemporary wars, NGOs, the military states, etc., use this vocabulary. At the same time, he argues, this vocabulary is rather flexible and underdetermined. So the net result is, according to him, that the laws of war provide the opportunity to make opposing claims in a language that is globally understood. And that, of course, fosters this strategic use of law. And what I find interesting, because one of the reasons why I was interested in setting out these different usages of the concept of lawfare was not to find the correct or true meaning of lawfare. That would be rubbish, of course, because meaning is socially constructed. So, but to analyze how a particular definition of lawfare is related to a particular way of organizing responsibility. What ways of holding people accountable are closed off or opened up by a particular definition and approach to lawfare. That is actually what is at stake for me in analyzing this. And here I found Kennedy's book particularly interesting, because what Kennedy argues is that this strategic use of law, while not in and of itself per se to be denounced, still raises fundamental concerns. One is what I already mentioned, the integrity of law. If everybody uses law strategically, and if everybody knows from one another that you use it strategically, what is left of law as a normative independent source? Legal discourse turns into a discourse of the deaf then. And secondly, he raises concern, that concern has also been raised by others, that personal responsibility for decisions regarding the lethal use of force is being replaced by legal calculus. And that actually there has been some empirical research also showing that this actually can happen in war situations. Now, at first sight, those seem to be two contradictory concerns. One is law is not taken seriously enough, and the other, law is taken too seriously. But I think if you dig a little bit deeper, what is at stake here is a very important point, namely the same basic idea that humanitarians in the military and other who are present in participants in war should acknowledge the freedom to take responsible decisions on the use of lethal force, including the decision to use law as a strategic tool. Okay, now let's go to the third, what I've called reflexive lawfare. That is the use of lawfare that is, I think, most common nowadays. The use of the term lawfare to denounce activities by others. And, well, the background is pretty clear. It's the rise of universal jurisdiction, the ICC, a stronger reliance on security, and the idea that we know what it actually means and what it is, and that we know what measures need to be taken, and that using legal fora frustrate that. And that is also, well, the definition that was put in the leaflet that was sent around, the 2005 defense strategy by the United States, where the use of law is put on a par with other instruments used by the weak, namely terrorism and international fora. And I think this is a very important transformation in the way in which lawfare is used, because for people like Kennedy, lawfare was a way to capture a new relation between law and war. Now, lawfare as a term, as a label, becomes an instrument in war or in political struggles. So I think it's a very fundamental transformation here. And that is why I came up with this term reflexive lawfare, which I then would define as the use of the term lawfare to discredit an opponent's reliance on law and legal procedure. And the other one is a more fancy one, but less accurate, but that shows where the reflexive comes from the use of the term lawfare as an instrument of lawfare. And so it's actually also a kind of a lawfare, but you use the term in order to discredit the other and to say, well, yeah, it's like saying I'm neutral, and the others have a position. Now, I think that there are three important ways where you can also see how this differs from the other usages of the term. First of all, generally, I mean, I generalize a little bit, so it's probably not true for every individual position, but I think the general picture is more or less correct. Generally, the use of the term lawfare is now reserved for activities by particular groups against particular governments. So there is no recognition that lawfare is an activity that everybody in contemporary wars engages in. The states, the military, and NGOs, and human rights groups, etc. No, the focus is mainly on non-governmental organizations. Secondly, lawfare is projected as something negative almost by definition, whereas in the other definition, that was not necessarily the case. It could have very bad results, but it depended on a particular context. And thirdly, I think the relation to responsibility has changed. For people like Kennedy, a term like lawfare and the whole analysis of the role of law also confronted him with his own previous efforts as a humanitarian to civilize war. And then he said, well, what has it brought us? So it propels a process of critical self-reflection. In the reflexive lawfare, the main aim is not to induce critical self-reflection, but the main aim is to show that others are acting irresponsibly because they hinder a government who is fighting for a good cause. So there are all kinds of different reasons, different meanings attached to the concept. Okay, to conclude, yeah. This is not to say that the use of lawfare should be abandoned. I think the concept is simply too powerful to remain there. It's not to say either that the use of law and legal procedure can never be criticized. There's very good reason to be critical about the use of law to solve political disputes, and I've tried to do that in the article that's in the book. But I don't think that using lawfare as a label to discredit the opponents helps us very much in this respect. On the contrary, I think it blinds us for the omnipresence of law in contemporary wars and for the ways in which legal arguments are used strategically by all parties concerned. And I think it seduces us to take a too comfortable position that we already know what needs to be done and that we can discredit the other party rather than inducing the process of critical self-reflection. Thank you.
Thank you very much, Professor Tiefenbrun and Professor Werner. I'll hand it over to you.
We will reconvene promptly at 10 o'clock. So there's a 10-minute break, coffee and food outside. The bathrooms are right to the right.